Good morning, and thank you very much for joining the Irwin Mitchell webinar on the impact of Brexit on employment and immigration. My name is Sibylle Steiner, and I am a partner in the employment team at Irwin Mitchell, and I am today joined by my colleague Ben Zhu, who is an immigration law specialist. We have quite a lot to go through in the webinar today, as you will be able to see on the agenda, which is on our next slide. So we will be looking at Brexit key dates, the EU settlement scheme, right to work checks, then the new UK immigration rules. We'll be looking at business travel to the UK and to EU countries. And last but not least, what's the future for employment rights in the UK? Before we start, just a few housekeeping points. You will be able to put questions into the chat function, and we will be trying to answer as many as we can at the end of the presentation. If you could please put your name and email address into the chat function, then we can contact you should we not be able to deal with the question during the webinar, but we will come back to you afterwards. There will also be a feedback form, and we'd be grateful if you could fill that in, because we always are interested to know whether there's anything we should be doing differently, whether there are any topics you liked in particular or topics that we haven't covered. So if you could fill in those feedback forms, that would be very much appreciated. So let's start with the webinar now, and if we could move on to the next slide, please. Now, Brexit dates, key dates. As we all know, the UK departed from the EU on the 31st of January 2020. And the transition period ended at 11 p.m. on the 31st of December 2020. And the new immigration rules are applying from the 1st of January 2021. Now, that is slightly different for EU nationals that arrived in the UK before 11 p.m. on the 31st of December 2020. Now, those EU nationals have until the 30th of June 2021 to apply for either pre-settled or settled status. Settled status will be granted if the EU national has worked or lived in the UK for 5 years, and pre-settled status if moved to the UK before 11 p.m. on the 31st of December last year, but not yet, but hasn't acquired yet 5 years of residency. So what does that mean for a business? It means that you can continue to employ EU citizens until the 30th of June without worrying, or EU citizens who have arrived before the end of last year, without worrying about the points-based system. What that doesn't apply, however, to EU citizens that arrive in the UK for the first time after the 31st of December, because they do not have the automatic right to remain or work in the UK, because if they arrive for the first time after the 31st of September, they cannot apply under the EU settlement scheme. And that then also means that if you have EU citizens who can apply for the EU settlement scheme but haven't done so by the 30th of June 2021, those EU citizens will have to leave the UK from the 1st of July, on the 1st of July 2021, because they will not be in the country legally after that time, after that date, if they have not applied for settled or pre-settled status, or if they do not have a right to stay under the new points-based immigration rules. Now let's have a look at the next slide, which will give some information about how an EU national can apply, what they need to do to apply for pre-settled or settled status. Now, again, just to repeat, this will only apply to EU nationals who will have been in the UK by 11 p.m. on the 31st of December last year. The application can be done online via an app. The app's called the EU Exit ID Document Check app, and that can be used on an Android device or an iPhone 7 or above. With Android devices, it's also not every device, so better to check before one is bought whether the app can be downloaded onto that device. What the device is for is that the EU national will scan their passport and will also scan their face, and that information is then being sent to the Home Office. An email is sent back, and some further information will have to be provided, which will prove that the employee has actually been in the UK prior to the 11 p.m. on 31st of December last year. So information that can be provided is national insurance number, residential address in the UK. There also have to be details of criminal convictions if there are any. And you may be, or the employee may be, required to submit pictures of scans of other documents. I went through this process myself. I gave my national insurance number, which I had now for 30 years. That somehow wasn't in the system, apparently. So I then sent council tax bills, for example, and that was accepted, and settled status was granted. Now, on the next slide, we will be looking at an interesting point, namely the right to work checks. As you know, you've got to do right to work checks after a job offer has been made. And there is a bit of confusion at the moment with regard to what right to work checks have to be done and can be done with regard to EU staff. The Home Office guidance says that employers cannot insist that EU staff provide proof of right to work under the settlement scheme until the 1st of July 2021. The government also says that it's not necessary to undertake retrospective right to work checks for EU staff that were employed on or before the 30th of June 2021. Now, if one sort of thinks about that, or thinks about that in a bit more detail, that can put you as an employer into a slightly tricky situation, because you may end up employing people on the 1st of July 2021 from the EU that either haven't applied for settled status by the 30th of June 2021, or you might be employing someone who has arrived after the 31st of December 2020 and shouldn't be in the country working based on a visa. So what to do as an employer with regard to those conundrums? With regard to existing EU staff, we would recommend to first send round communication generally to staff as a whole, advising them about the EU settlement scheme, what happens if there isn't a registration by an application by the 30th of June. So general information out to all staff. Then possibly sort of around April, May time, write to your EU staff members, invite them to let you as the employer know whether they have applied for settled status. The emphasis is on invite, not require them. And then after the 30th of June, so from 1st of July onwards, ask EU staff to provide the information. Now, the Settled status, if people have applied for it, or pre-settled status, they don't get a document. It's only online. So that although there will be an email from the Home Office saying you have been granted this status, that's not sufficient evidence of having obtained it. The employee needs to go into the website, obtain a code, give that code to the employer, and with the help of that code as an employer, you can check then online whether the employee has applied for settled or pre-settled status. Now, what to do with EU staff that you want to start employing between now and the end of June this year? That's a difficult question because you can't really ask whether they have applied, because that might be discriminatory. So what can be done, maybe look at the employment history. If all the previous employment was outside the UK, then there's a likelihood that the employee was not in the UK by the end of last year. Make sure that the offer letter is drafted in a particular way to put the onus of providing information onto the EU applicant. And I think in any event, take legal advice if you find yourself in that situation, to make sure you get it right and that you don't expose yourself to possible discrimination claims. We do have an FAQ document that explains the system that employers can use to inform staff. So if you're interested in that, we can send that to you. Now, that is all from me at the moment with regard to the EU settlement scheme and right to work checks. I now hand over to Ben, who will be taking you through the new immigration laws and visa requirements should you want to employ someone who doesn't have the right to work in the UK under the EU settlement scheme.
Thank you, Sibylla. Good morning, everyone. My name is Ben Xu, and I am an immigration specialist at Owen Mitchell. So today I will try to cover some of the changes that happened in the last couple of months, immigration changes as a result of Brexit. As Sibylla mentioned earlier, the UK left the EU on the 31st of January 2020, and a transition period kicked in immediately after that, lasted for 11 months and ended on the 31st of December 2020. A new points-based immigration system was then introduced on the 1st of January 2021, which applies equally to EU citizens and non-EU citizens looking to relocate to the UK, except Irish nationals, who will still have the right to remain and work in the UK without visa. So what does that actually mean? It means that EU citizens are now being treated in the exactly same way as all other non-EU nationals, unless you have already acquired EU settlement scheme status. They would need to apply for a visa under the new immigration system in order to visit or remain in the UK, whether it is for the purpose of studying or working. So EU nationals are therefore ought to start getting into the habit of planning before action, especially if the reason for the purpose of their trip is for work purpose. There are 4 questions in general, I would say, you need to ask yourself before you make any plans to travel to the UK going forward. Why, what, when, and how? Why do you need to travel to the UK, and for what purpose? Is it for personal leisure or business purpose? So what kind of activities you intend to carry out while you're in the UK? And that question directly linked to the type of visa you need to apply for if one is required. When do you need to intend to travel to the UK, and how to make a visa application? So those are the questions you absolutely need to ask yourself before you even make any plans to travel to the UK. So in the post-Brexit world, so you have to think it through and make sure that you know the answers to all 4 questions before you picking up your passport and hopping on the plane. So it's very important to answer those questions. If you're in doubt, I would definitely suggest that you speak to your legal advisors before travel. For employees, as I'm sure most of you are, the questions you have in mind is probably, what rules and policies you have to follow under the new regime when it comes to recruitment. A simple answer is that if you're looking to hire a non-British Irish national going forward, the assumption is that you would require sponsorship. They would require sponsorship from you, unless they have an EU settlement scheme or visa granted under the new immigration system, which allows them to work in the UK. For example, a spouse visa or global talent visa. And to sponsor someone, you as an organization must firstly apply to the Home Office for something called a sponsor license. Next slide, please. So what is a sponsor license and how do you apply for one? A sponsor license are licenses granted by the Home Office to companies, organizations in the UK, which allows them to employ migrant workers to fill a skilled occupation. What the Home Office often say is that the sponsorship is a privilege, it is not a right. Meaning that if you're benefiting directly from the sponsor licensing system, you must play your part in ensuring that the immigration system is not abused and to comply with wider UK law, for example, the employment law, prevention of illegal working, minimum salary regulations, so on and so forth. One thing you have to note is that not every entity in the UK could get a sponsor license. To be granted a sponsor license, you must be able to demonstrate that you meet certain eligibility requirements. As you can see, I've listed the key requirements here. Generally speaking, when considering an application for a sponsor license, the Home Office will need to establish whether the business is operating lawfully, legally in the UK, whether the key workers in the business are honest, dependable and reliable, whether the business itself is able to comply with the sponsor duties once the license is granted, and whether the business can offer genuine employment that meets the appropriate requirements such as the skill levels and salary levels for the visa. Next slide, please. In terms of the application process, you will have to complete the online application form and nominate someone to manage the license once it's granted, pay an application fee, which is about £536 for small and charitable organisations, and £1,476 for medium or large size organisations, and send certain supporting documents to the Home Office as evidence of you meeting the relevant eligibility requirement for the licence. There's a possibility that the Home Office might carry out pre-license visit to ensure that you are who you say you are, and that you have a robust HR system in place, i.e. you will be able to meet your sponsor duties and responsibilities once the license is granted to you. The standard processing time is up to 8 weeks, but with additional £500 you will be able to get a decision within 2 weeks. Once granted, the license lasts for a period of 4 years, which can be extended for another 4 years. As I mentioned earlier, sponsorship is a privilege, as the Home Office often say, not a right. Therefore, the Home Office places a huge amount of trust in their sponsors. With that trust, obviously, comes with direct responsibilities to act in accordance with the UK law and sponsorship duties. What are the key duties then? The key duties that I have listed here that all sponsors must adhere to. I've only listed 3 of them, but there are more. For example, cooperating with the Home Office throughout the life of your license. But these 3 are the key ones that all sponsors must know by heart. Sponsors must ensure that they have a robust system in place. Firstly, monitoring to monitor their employees, and for example, carrying out the right to work checks, knowing what documents to check, and knowing when and how to check them. Then the reporting duty in circumstances where a migrant worker fails to turn up at work without permission, for example, or when the structure or ownership of your company changes. he must then report to the Home Office within a certain period of time. For example, a report must be made within 10 working days if a migrant worker has basically been absent from work for more than 10 consecutive working days without permission, or within 20 working days if there are significant changes to your organization, such as you change your name or you merge with another organization. With changes for ownership, you might have to submit a new sponsor license application, and such application has to be submitted within 20 working days of the change. Last but not least is the record keeping duties. I mentioned earlier about the Home Office carrying out pre-license visit. The Home Office do have a habit of carrying out a post-license visit and checks as well, just to ensure that you are keeping all the documents that you promised that you're going to keep. Your HR files are in order, and make sure that all the documents kept is everything that's required for you to keep. For those who are familiar with sponsor license systems, might know that the resident labour market test has been scrapped, which is definitely good news. Resident labour market test was the mechanism that was put in place, introduced by the government back in 2008, and lasted up until 1st of December 2020, to ensure that settled workers in the UK, which also included EU nationals back then, had the opportunity to apply for jobs before they are offered to migrant workers. So that was the scheme we had in place before 1st of December 2020. Like I said, the resident labour market test has now been scrapped, but what a lot of people are not aware of is that the rules regarding record keeping duties, i.e. the kind of documents that must be kept by all the sponsors, remain the same. This means that sponsors are still required to keep records of their recruitment activity, including job adverts, which has start date, end date, job title, location for job, and then duties and responsibilities, skills, qualifications, and experience needed, and an indication of the salary package. If for whatever reason your adverts do not contain those required images, it might be the case that you might have to re-advertise the role again in order to meet the Home Office requirements. This, of course, in the last couple of months, caused a lot of controversies. As Inken mentioned, the good news is that the Home Office has said that they're currently reviewing and amending their policies, and it will release the revised version shortly. So watch this space. Next slide, please. So once you have got your sponsor license and made an offer to your migrant workers, they will then need to apply for something called a skilled worker visa. The reason why it's called skilled worker visa is because unless the job you're offering is on the skilled occupation list, i.e. meets certain skill level, you will not be able to sponsor a migrant worker for that role. Let's move on and look at the key requirements for skilled worker visas. Broadly speaking, there are 6 requirements. Firstly, the job offer has to be made by an employer approved by the Home Office, i.e. an organisation that has a sponsor license in the subcategory of skilled worker. Secondly, the job in question must be on the skilled occupation list published by the Home Office, which means that the job has to be at RQF level 3 or above. Anything below that level 3, means that you cannot sponsor them. Thirdly, the salary requirements. The salary you're paying must meet minimum salary requirements, and the minimum salary requirements here is where the confusion lies. You absolutely need to know how to calculate the minimum salary for different roles. The headlines is that the absolute minimum salary that employer can offer to a migrant worker in the UK for a job is 20,480. But depending on the going rate for that particular position that's on offer, the minimum salary threshold could be higher than that. We'll talk about that in more detail later on, and I will also give you an example in the next couple of slides to explain what that actually means. So that's minimum salary requirements. In addition, there's also the applicant must also demonstrate the fact that they meet the English language and also financial requirements. The last requirement, criminal record requirement, is only relevant to certain jobs that involves vulnerable people, dealing with vulnerable people such as health professionals and doctors, nurses, social workers, teachers, and so on and so forth. Next slide, please. Now let's talk about minimum salary requirements for a minute. I have here a screenshot of some legal occupations from the Home Office's skill occupation list. I'm, for one, actually really glad to see that solicitors that made to the list. Otherwise, I would probably be put on the next plane by the Home Office, deported back to China. So good for me. Back to salary requirements. What you will see is from the table is that there are 4 rates in respect for each occupation. And let's take solicitor as an example. The going rate, option A, is 34,300, and 90% of that going rate is 30,870, which is option B. Option C and D are 80% of the going rate, which is 27,440, and option E is 70% of the going rate, which is £24,010. So what do they actually mean, and which rates should you use then? The next table will give you all the answers you need. Please, thank you. Depending on the applicant's personal circumstances, different rates would apply. Option A is the going rate benchmark, if you like. Option B is for individuals who has a PhD degree, and their PhD degree is relevant to the job they are sponsored for. Option C is similar to option B, but subject in question is one of the STEM subjects, science, technology, engineering, mathematics, that's STEM subjects. Option D for jobs that's on the shortage of occupation list published by the Home Office. And option E is rates for new entrants, such as new graduates. And option F is a list of health and education occupations, which is why it's not showing as an option on the example I've just given to you. Next slide, please. Let's go back to solicitor that example. So options C and D are not really relevant here, as the solicitor is not a job that's on the current shortage occupation list, nor is it a STEM subject. So therefore, options C and D are not really relevant when it comes to solicitor as an occupation. So the 3 relevant rates are options A, B, and E. If you're looking at recruiting an experienced migrant worker, for example, who has no PhD degrees, then the minimum salary is then the going rate, which is 34,300. If the person you're hiring has a PhD degree in criminology, for example, and the job on offer is a criminal solicitor role, which is obviously relevant to the PhD that the migrant worker has, then the minimum salary threshold reduces to 30,870, which is option B. If, however, the person you are hiring is a new graduate or someone who meets the definition of a new entrant, then the rates of option E applies, which is £24,010. I know it's probably not the most easiest, table to navigate, but I hope my explanation give you a little bit of clarity when it comes to calculating minimum salary thresholds. Next, please. Due to time constraints, and so I'm not going to go through the definition for the new entrants, but the most used ones are the first one. The applicant is under the age of 26 on the date of their application, and the last one, which that applicant is a recent UK graduate. Next slide, please. The last point I would like to cover on skilled worker visa is the fees involved. As some of you probably already know, when you sponsor a migrant worker, you will need to assign a certificate of sponsorship of that particular migrant worker, which costs about £199. As an employer, you must also pay something called immigration skills charge, which is £364 per year for every year that you would like to sponsor that particular individual, if you're a small or charitable organization. But if you're a medium or large organizations, the cost goes up to £1,000 per year. So for a 5-year visa for medium, large size organizations, it will probably cost you about £5,199 to sponsor one person, and that cost cannot be passed on to your workers. In addition, there are also visa application fees. As you can see, I've put on the slides, there are 2 sets of 3 fees, 3 rates. And the first set of 3 is for visa applications made up to 3 years. And the second set of 3 is for applications made for more than 3 years, i.e. 5 years. That is the duration of the visa you're applying for. The 3 rates are intern job on shorter occupation list, which is the cheapest rate, application made outside of the UK, and application made inside of the UK. As well as the application fees, there's also immigration health surcharge that need to be paid by the applicant, which is about £624 a year. So it all adds up. Unfortunately, it sounds like a proper money-making scheme designed by the Home Office. Unfortunately, it's just not a cheap process. Next slide, please. But what if you are an EU citizen who want to visit the UK for a short business trip, for example? You can do that under the visitor visa scheme, provide that the activities you intend to carry out in the UK falls within one of these categories. Remember the 4 questions that I mentioned earlier of my presentation that I suggest you to ask yourself before travels. One of which was what kind of activities you intend to carry out while in the UK. If, like, say, you intend to come to the UK and attend meetings, conferences, or seminars, or come to the UK because you are the employee of foreign manufacturers wanting to come to the UK to install the products that you sold to the UK-based customer, you might be able to come to the UK under the visitor visa scheme. Otherwise, you might have to consider the sponsorship route. Thank you very much. I will hand it back to Sibylla now. Next slide, please.
Of course, I did the usual thing that I forgot to put myself on the microphone, so apologies for that. Thank you very much, Ben, for this whistle-stop tour through the new immigration rules and also the business travel to the UK. As you will have seen from the slide, business travel to the UK is still possible, but there are quite a few hurdles that need to be taken, and unfortunately the reverse or the same applies when it comes to business travel into the EU. Now, first of all, there are extra requirements for business travellers, what they need to show at the entry into the EU. So the traveller should have certain documents with them, so there should be a passport, and the expiry date should be not more than 3 months, or should be at least 3 months from the intended departure from the member state, and the passport should have been issued within the previous 10 years. The business traveller should also have documents with them sort of confirming the purpose, the duration of the trip, demonstrating accommodation, and also that there are funds available. Now, does one need a visa for business travel to the EU? One of the main things to remember with regard to that is that, obviously, I'm stating the blindingly obvious now, the UK is now a third country, and that means that as a business you really need to consider 27 different national immigration regulations and rules on work permits when it comes to business travel. Now, the overall, obviously we can't cover 27 countries' business travel rules in the context of this webinar, but I just sort of want to give some overall points to consider. Now, first is that a visa or work permit or other documentation probably needed for people who are planning to stay for longer than 90 days in a 180-day period, or where the trip to an EU country is because the person is transferring from a UK branch of a company to a different company, so where there is an inter-corporate transfer, even if that is for a short period of time, where the individual wants to carry out contracts to provide a service to a client in another country where the employer does not have a presence, or where there are services provided in another country as a self-employed person. There are a limited number of business activities that are likely to be permitted. Ben had listed a few on his slides: business travel to the UK and similar business activities are allowed in EU countries as well, like going to a meeting with a colleague or with a client or attending a conference and so on. Now, what is important to remember in this context is that basically the visa requirement is not triggered by the duration of the stay, but by the activities that are being undertaken. So just to say that, it's definitely not longer than 90 days in a 180-day period, and we therefore do not need to think about what the activities are that our employee wants to pursue in the EU country, that is not sufficient. You also need to bear in mind that where a person is traveling for business purposes in connection with a profession, are they actually allowed to work based on that profession, and are the professional qualifications recognized in that other EU country? That's an additional headache, additional requirement to think about should a person be traveling in connection with a profession. Now, there are specific provisions where an UK citizen is coming to the Schengen area. Now, the Schengen area that covers Iceland, Liechtenstein, Norway, Sweden, and all of the EU countries except Bulgaria, Croatia, Cyprus, Ireland and Romania. And the arrangement there is that if a person comes for a short stay of no more than 90 days in a 180-day period to a Schengen area country, that person will be allowed visa-free travel. So for any longer stays, the member states apply own rules with regard to that. So where frequent travel is undertaken, you need to sort of calculate carefully that these 90 days in any 180-day period are not exceeded. However, in addition to that, so this all sounds good, but in addition to that, member states can decide individually whether there are any other requirements with regard to that over and above the duration. So is it required, is it allowed to come to the Schengen area, or some countries say it's irrespective of the time duration, a person can only come to that country if they are not there for a paid activity, and if they are coming there for a paid activity, irrespective of whether that might be for less than 90 days in a 180-day period, they would nevertheless need to apply for a short stay visa. Now, what does paid activity mean? Now, that is defined very broadly, and it is also defined differently by different countries. So even when it comes to business visits to Schengen area countries, as an employer, as a business, you need to think about, you need to check for the country that your employee would like to go to by way of business, whether there are any requirements with regard to paid activity, economic activity, and does the purpose for the visit require to apply for a visa nevertheless. Now, where for a Schengen business visa, there are a number of sort of documents that need to be provided. So, as I mentioned already at the beginning, the purpose of the intended journey, so invitation from a firm, another business authority to attend a meeting, or other documents that show that there is a trade relationship or that there is a visit for work purposes. If there is a visit to a fair or congresses or something like that, entry tickets, documents providing the business activities of the company, and also documents showing what the applicant's employment status is with the company. Documents showing that there is accommodation, and also that means there's sufficient cover, financial cover for the accommodation, proof that there's sufficient financial means for the duration of the stay, of the intention to leave the Schengen area before the visa expires, and also proof of travel medical insurance, should be a minimum coverage of 30,000 euros, and that should be valid throughout the territory of the member state. And if possible, that should be taken out with a company either based in the UK or in a member state. And obviously the insurance should cover the period of the whole stay. Now that shows you that, again, also with regard to business travel to the EU, it is of vital importance to think about it beforehand, i.e. before an employee jumps on a plane to go over to another EU country. And it's probably also advisable, should you have a travel policy, travel documents dealing with that, that those policies are updated to reflect the additional issues in relation to business travel to the EU. That is it on business travel. So before we get to questions, let's have a quick look at the next slide, the future employment rights in the UK. Now that the pace of any change in relation to that is likely to be very slow. The UK has preserved laws and decisions of the ECJ on the 31st of December 2020. So those laws and those decisions still apply. However, the Withdrawal Act gives the right to the UK Supreme Court and the Court of Appeal to depart from retained EU case law if they consider it right to do so. Now that gives the courts the scope to diverge from EU retained law, and that could lead to uncertainty as established legal principles are possibly relitigated. However, as I said, I think the pace of that is likely to be slow, so we will have to watch and see what happens with this regard. The trade and cooperation agreement that the EU and the UK reached establishes the principle of level playing field. So that will make it more difficult for the EU, for the UK, and obviously the EU countries as well, to dismantle any employment rights without consequences, because there are provisions in that agreement that existing rights will be preserved, and that countries will also strive to increase them. So that is likely to give the UK government much less scope to make any serious changes than people who were supporting Brexit may have wished for. You may have seen that a few weeks ago there initially was going to be a consultation with regard to possible changes of employment law following Brexit, and then that after an outcry was quickly binned, so that consultation is now not going to take place. No doubt for the reasons that I've just explained, namely that it will not only be difficult, I would have thought, to sell it politically, but it would also have, or likely to have, an impact on the level playing field arrangement in the trade and cooperation agreement. So that was our last slide in the presentation. And that gives us an opportunity now to go through the questions. Thank you very much. You've been asking some really great questions, and we will see whether we can get through all of them. But as I said at the beginning, if we can't, we'll contact you afterwards. So first question we have is, should staff who have an Irish passport be treated as British or EU citizens, or do we require any further documentation from them, please? Ben, do you want to, you mentioned that there's an exemption anyway with regard to Irish citizen under the Common Travel Area Arrangement. Do you just want to expand a bit on that?
Absolutely, thanks, Sibylla. As Sibylla mentioned, pursuant to the Good Friday Agreement, which means that Ireland and UK are part of this common travel areas. So what that means that Irish nationals who want to come to the UK, stay in the UK, work in the UK, they should be treated as any other British nationals. Therefore, when it comes to right to remain, right to work, and right to work in the UK checks, you can take their Irish passport as evidence of their right to work in the UK.
Thank you, Ben. The next question is an interesting one and an important one, particularly bearing in mind the COVID pandemic. That's about an Italian employee who's been employed in the UK for nearly 3 years, and the employee returned to Italy before Christmas and is due to come back to the UK in April. Now, that person wasn't in the UK on the 31st of December 2020, obviously, and should it be possible for that person to return to the business to work for them?
That's a really good question. I think it sort of depends on the personal circumstances of that particular employee. If, for example, the relevant employee is an Italian employee who's been working for you for over 5 years, you said mentioned 3 years, and who's been living in the UK for more than 5 years, what that means that he would be able to apply for settled status based on the 5 years continuous residence in the UK, to make that application. And I do not foresee any issues of him getting settled status on that basis. Even with pre-settled status, i.e. the person who's been living in the UK for less than 5 years, there's a concession. What that means is that there would be a continuous period of residence means that you live in the UK, you're not absent, you haven't been absent from the UK for a period of 6 months in any given 12-month period. So if he left the UK in December, when went home for Christmas, and decide to come back in April, that's still within that 6 months period. So he would still be able to apply and make an application for pre-settled status or settled status. One thing to note is that the pre-settled status or settled status under EU settlement scheme, that application can be made by people who are actually outside the UK. So you don't need to be in the UK to make such an application. He will probably need to submit his evidence, i.e. employment contracts or pay slips from you, or council tax, bank statements to prove that he was actually he has been living in the UK for longer period of time.
Thank you very much, Ben. Of course, there is potentially a problem with regard to employees who say left the UK in April or May last year because of the pandemic and haven't returned, and that might be problematic based on those facts, whether continuity of residence still applies. But I think, as you said, again, it's important to take advice with regard to the individual circumstances of the employee in question. Then we have a question about whether an EU-based self-employed worker needs a visa to provide remote services to a UK company. Well, if that EU-based self-employed worker is not an EU national, then they will need a visa to do whatever they're doing in the EU country that they are working, but they wouldn't, I suppose, need a visa for the UK unless they want to come to the UK for business reasons, and that wouldn't, unless that's not covered by permitted activities, then they might need a visa, but otherwise I suppose they don't.
Absolutely. When it comes to remote working, what you need to look at is whether or not that person is actually needs to be physically in the UK. That's when the immigration rule kicks in if the person travels to the UK and has to carry out certain activities in the UK. So that's the questions to remember, the 4 questions I mentioned during my presentation that you need to ask yourself.
Yeah, and we have a question that sort of goes with that as well, which is if an EU-based individual is providing a remote service, either on an employed or self-employed basis, to a UK company, which jurisdiction governs the contract. So when it comes to employing someone outside the UK and that employee habitually works outside the UK, then the mandatory employment rules of the country where that employee works would apply. So although you can, as a business, provide the employee with an English law employment contract, you will need to bear in mind that in addition to that, the mandatory rules of the country where the employee works, the mandatory employment rules, will apply on top of that. And mandatory employment rules are usually most of the employment protection rules in any particular country. So in that situation, as an employer, if you had a contract under English law, but the employee, say, lives and works habitually in Germany, you would need to operate both under English and under German law. And what makes it even more difficult is that the employee in that situation, for every single situation they might find themselves in, they can pick and choose which law they would like to apply for that particular situation. So it's not a question of the employee saying we want German law overall to apply or we want English law overall to apply. Whatever happens, they have a choice and they can jump between the two laws. From experience, I can say that's highly it's very interesting for the lawyers involved, but as a business, and it can be very beneficial for the employee, but for the employer, for the business, our advice is usually employ people under the local employment laws, because that makes the life of the the employer easier. Also, where you have employees in other countries, you are still liable for health and safety, for example. So you need to make sure that the work where the people work complies with health and safety regulations in that country. You will also need to consider whether the employee working in the country may have tax implications for you as the business. So whether that might create a permanent establishment with tax applications and so on and so forth. So there is a whole raft of considerations that need to be undertaken before you should agree to an employee working remotely for you in another country. For a self-employed person, that is the rules with regard to the laws that apply to the contract are different with regard to self-employed people. So you may have a contract under English law with a self-employed person, but please bear in mind that the question of status, whether employed or self-employed, the issues we have here in the UK may apply in the other country as well, and the employee and the self-employed person might actually not be regarded as self-employed after all by the courts. Then question with regard to sponsorship: is it possible to claw back the cost of sponsorship if the employee leaves?
It depends. As I mentioned earlier, there's a signing fee for certificate sponsorship, and there's also immigration skills charge, which is cost about £1,000 per year for every year you would like to sponsor that particular migrant worker. There's a specific rules and regulations in place specifically prohibiting employers to transfer those costs onto employees. But on the other hand, when it comes to visa application fees for skilled worker visa and also immigration health surcharge, so often a decision for the employer to decide whether or not you would like to pass that cost onto the employee, or would you like to absorb that and cover that cost as well. Obviously, any cost that you're looking to cover, that would be considered as some sort of benefit, and could be, taxed on. The employee might have to pay tax on those costs that you're covering for them when it comes to visa applications. And accrue back, I think there might be also employment issues as well. Sibylla, do you think trying to put clause in their employment contract saying that if you leave the employment within the next couple of years, we have the right to
I think that might be. I think it might be difficult to do that. As you mentioned earlier, Ben, it's not possible to sort of ask the employee to bear the costs for the visa applications. So I think reclaiming it might be difficult as well. I'm conscious of time. I think two quick questions. Is it after pre-settled status has been granted, will settled status then be obtained automatically? I think the answer to that is no. You have to apply for the settled status. It doesn't just happen automatically. And then I think the last question that we can deal with now is whether you can ask an EU worker if they entered the UK on or after the 1st of January 2021. That is indeed a difficult question. If we are thinking ahead about from the 1st of July onwards, then you need to do a right to work check, and the employee needs to provide that. But if you want to employ an e-worker at the moment, then you, according to government guidance, you shouldn't really. You should only, it's sufficient for them to show their passport, and that's all that you really should be asking at this point, because if you ask more questions, that might be regarded as discriminatory. There are sort of, as I mentioned earlier, ways of looking at it and ways of drafting offer letters, and we would of course be very happy to to deal with those on an individual basis, because it does also depend. One should look at every individual employee separately. So that brings us to the end. Thank you very much for listening. And as I said, questions we haven't answered, we'll look at afterwards. Please fill in the feedback form and stay safe. Thank you.